Last week, as he defended Montana's new restrictions on abortion, State Attorney General Austin Knudsen asked the Montana Supreme Court to overturn a 22-year-old decision by a prior court known as Armstrong. That's because Knudsen, a staunch opponent of abortion, knows if Armstrong stands, the abortion restrictions may fall as unconstitutional. So what is the Armstrong decision, and why is it so important in the abortion debate in Montana? MTN Chief Political Reporter Mike Dennison tells us.
The decision came in a lawsuit from a Kalispell doctor, James Armstrong, and his physician assistant, who had been performing abortions for many years. They challenged a 1995 state law that said physician assistants could not perform abortions, saying the law was an unconstitutional infringement on a woman's right to choose her healthcare provider for a legal procedure. A unanimous Montana Supreme Court in 1999 ultimately agreed, saying the law violated Montana's state constitutional right to individual privacy. Then Justice James Nelson, who still lives in Helena, wrote the lengthy decision.
I think the important thing is that the right of a woman to choose a pre-viability abortion is grounded in the right of individual privacy that the Constitutional Convention, the framers, considered probably one of the most important fundamental rights that they were providing.
But now, Knudsen is asking the current Montana Supreme Court to overturn Armstrong. His Assistant Solicitor General, Katie Smithgall, says the ruling overextends privacy rights to cover abortion.
It creates a right that simply does not exist in the Montana Constitution. The legislature has enacted these laws, and they're common sense health and safety measures. And the legislature has the authority to act in that space.
The laws in question, passed last year by Republican majorities at the legislature, outlaw abortion after 20 weeks of pregnancy, severely restrict access to abortion pills, and require doctors to ask abortion patients if they want to see an ultrasound of the fetus. Planned Parenthood of Montana is suing to overturn these laws, saying they violate Montana women's right to medical privacy as defined in the Armstrong decision. Here's Martha Stahl, the president of Planned Parenthood of Montana.
Our argument is that all of those things restrict the ability of a patient to seek abortion care pre-viability from the provider of their choice.
State District Judge Michael Moses of Billings cited Armstrong in blocking the laws from taking effect last year, while he decides whether to strike them down permanently. Knudsen has appealed that initial decision to the Montana Supreme Court and asked the court to reverse Armstrong. Stahl says she thinks the request is premature, made before a final lower court ruling on the laws.
I think it's really a political statement more than anything else.
But both Stahl and Nelson say Knudsen is wrong when he says Armstrong was judicial activism that needs to be undone.
The decision was grounded in a very strong, thorough analysis of Montana's Constitution, the underpinnings of the right of individual privacy, and it was not based on some sociological decisions by the judge.
They also say if Armstrong stands and the abortion laws fall, it probably can't be successfully appealed to the U.S. Supreme Court because it's strictly a state issue.
In cases around challenges to state laws that are brought under the state constitution, those do not go up to the U.S. Supreme Court. They would go to the Montana Supreme Court, and that's as far as they can go.
The Montana Supreme Court may decline to rule yet on Armstrong, and instead wait for the Billings District Judge to make his full ruling on the constitutionality of the abortion laws. But whatever is decided, you can be sure that Armstrong will be right in the thick of it. Reporting from Helena, Mike Dennison, MTN News.